On September 17, 1787, 216 years ago, the framers of our Constitution, led by James Madison, ratified the Constitution at the Constitutional Convention in Philadelphia. The Constitution has undergone several changes since 1787, with the addition of 27 amendments since 1789. The courts have interpreted and reinterpreted many parts of the Constitution over our history. The Fourth Amendment and the right to privacy, ever since Griswold in 1964, has often provided a great deal of public debate. Today's speaker for Constitution Day, Scott Shellenberger, on a daily basis deals with the Fourth Amendment issues such as the right to privacy, etc. He will discuss the Fourth Amendment, privacy, and how law enforcement and the Baltimore County State's Attorney's Office uses social media to catch the bad guys. Mr. Schellenberger began his legal career in the Baltimore County State's Attorney's Office, working as a law clerk while attending law school at the University of Baltimore. After being admitted to the Maryland Bar in 1985, Mr. Schellenberger began working as a prosecutor, where he quickly gained a reputation as an advocate for victims of crime, moving through the ranks in the state's attorney's office. He also has served as a supervisor of felony screenings, career criminal and automobile manslaughter units, and chief of the Child Abuse Sexual Assault Division. Mr. Schellenberger was elected the state's attorney for Baltimore County in 2006 and re-elected in 2010. He was instrumental in the passage of an expanded DNA law, which has given law enforcement agencies the opportunity to prevent violent crime. As we have seen recently, the role of the state's attorney is critical in the community as an advocate and a prosecutor. Now it is my pleasure to welcome Baltimore County State's Attorney Scott Shellenberger.
Thank you so much, and thank you all for being here today. As the state's attorney in Baltimore County, I employ 59 assistant state's attorneys, and what we do every day is prosecute criminal cases that occur here in Baltimore County. And as John said, one of the most important things that we do, and our partnership with the police department is what we do every day we have to uphold the Constitution. So, you know, the Constitution and the Bill of Rights are what allow us to drive our cars down the road without being pulled over for probable cause, allows us to be in our houses when the police officer knocks on the door and say, no, you cannot enter unless you have a warrant. And it allows us to have personal, private conversations on our telephones without anybody listening. And therefore, you know, not only do law enforcement, but the state's attorney's office every day really do live and breathe the Constitution. So the reason that we're here today, as John said, was that September 17th was when the delegates of the Constitution Convention convened. And the reason that obviously that is important is that it actually took several years before it was ratified by the states. And what happened was that while they were out in the field trying to get the states to ratify the Constitution, a lot of the citizenry just plugged up and said, you know, look, we just got rid of one very big government that we were sick of. You know, we need some protections here for the people in our Constitution. And as a result of that, we got the first 10 amendments to the Constitution. And certainly all of those amendments are important. Nobody would want to put free speech or a right to free religion above any other ones, like the right to not have a confession that's beaten out of someone. But certainly one of the very, very important amendments to the Constitution is the Fourth Amendment. And it's the basis, the Fourth Amendment is the basis for what everybody believes gives you the right to privacy here in this country. Now, here's the Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. This is what prevents the police from busting into your house, pulling over your car, frankly, walking in here right now and rifling through your notebooks, your personal papers. The problem is so much of what we do nowadays you think is private, but it is not. And I'm going to show you how law enforcement solves crime nowadays by the use of modern technology that you all might think is protected, but it isn't. So the question that we're going to talk about today is, what happens when that Constitution collides with your right to privacy out there in the world of social media and really out there in public? And that is really one of the crucial issues that is going to come about in all court cases now. And I suggest over the next several years, you're going to see a number of cases that make it to the Supreme Court that deal with this collision between these competing items. Now, all of you probably know what all of these things are. 15 years ago, none of these things existed. YouTube, Foursquare, Facebook, Tumblr, Instagram, all this stuff that you all use all the time is social media that's out there. It's out there and it's available for all of us to see. It's the way we all communicate now and then. I'm fairly convinced that if two people are sitting together back there, you wouldn't talk to each other anymore, you would text each other, because that's the way people communicate, particularly people of your age group. So the question is, how are we using social media to solve crime? And the place that I'll start is with new technology. Right here, as we're sitting here now, if you have a phone that's been manufactured within the last 5 years, your phone at every minute is searching for the closest cell phone tower. We call it pinging, based on the old sonar from the old submarine days. And what happens is, if you went to my carrier right now, AT&T, and an engineer looked at where my phone was, he could tell you within about 200 yards of exactly where I was standing. He would be able to tell you, because Essex campus is so big, that I am on the campus of Essex Community College. And that happens with every one of your cell phones. Unless you have one of those old flip phone crank models, which I'm sure none of you do, any engineer for any of your carriers would be able to tell you where I'm standing right now. We're using all this technology in fighting crime. The best example is, if 3 people rob a 7-Eleven and we catch one of them, where do you go to find the other 2 co-defendants? You look at the call history of the person who is arrested. You find out who his friends are by who he's been calling over the last several hours. The other place we go is computers. If you think when you hit the delete button on your computer that it actually is deleted, well, you are wrong. You can hit the delete button all you want, but a good forensic computer person can dig into that computer and find out what you've been looking at. Well, why does that matter? Well, it matters if you've been looking up, how do I construct a bomb? Or how do I kill my husband? And if we catch you and go into your computer and find this stuff, it can be very important evidence. Surveillance videos are everywhere. I'm going to show you an example of that. You think you're walking down the street and nobody's paying attention? Well, you're wrong. Your likeness is being recorded by thousands of cameras. Our jails, if you get arrested in our jail and you make a phone call out, it's recorded. And thank goodness, people who are in jail are usually stupid, and they will usually say things that we can use against them in court. And finally, when we interview defendants now, we videotape them because jurors want to see how the police treated them. And so we want to bring the best possible evidence to everybody when we're trying to convict a person of a serious crime. So let's give an example of how all this comes together in order to solve crime. You may have heard that December of 2011, there was a murder at the Towson Mall. Rodney Pritchett was gunned down outside on Fairmont Avenue. It was a targeted crime. He had been targeted by gang members of the Black Guerrilla family because of some affront that he had done to them. And so on that day, after Rodney Pritchett's body was found, this man, Frank Williams, was found wandering up and down the stairways at the Towson Mall. He was sweating, he was upset, he kept walking up and down the stairway, and of course there's one of those video surveillance cameras that captured that. So what the police did was they pulled Frank Williams into the police station. They really didn't have much of an idea whether he committed a crime or not, but Frank Williams had done the one thing that so many people do at the Towson Mall. He got lost trying to find his car. You see, he made the mistake of parking on the Nordstrom side and walking to the Macy's side. And you can't do that because you get lost. They don't cross over properly. So when Frank Williams gets taken out of that stairwell, law enforcement did the best thing that they can do nowadays, and that is they grabbed his cell phone. They grabbed his cell phone, and what they did was they looked at his phone records. because they provide the connection of who Frank Williams had talked to over the last several hours. Every good police officer now, when they arrest a suspect, the first 3 questions they ask them are, what's your name, what's your cell phone number, and do you always keep your phone with you? And invariably, everyone says, this is my name, here's my cell number, and I never ever give my phone out to anybody. I would never do that. And that's what they did with Frank Williams. They questioned him, they asked him these questions, and then they let him go. They let him walk right out of the door. He was free to leave, and he did leave. But when they got his phone records, this is what they found. Frank Williams, in the 2 hours around the time Rodney Pritchett got killed, had all these communications with Jermell Brandon, William Ward, and Tyrone Brown. What we later learned is that Frank Williams and William Ward were the head of a gang, a sect of the Black Guerrilla family in Baltimore City. Jermell Brandon was shopping at the Towsontown Mall when he spotted Rodney Pritchett shopping. And Tyrone Brown was trying to earn his way into the gang, and the way you do that is by accomplishing a mission, and this mission was to gun down Rodney Pritchett. So by finding Frank Williams in that stairwell and getting his cell phone number, each one of these numbers was a phone call made between these individuals during the 2 hours surrounding the murder of Rodney Pritchett. All the police had to do then was get their photographs either from MVA or mugshots, and then all they had to do was look at the 268 cameras that are at the Towsontown Mall. That's right, 268 cameras. When you walk around that mall, every second you're being recorded. You think you're being in private? You are not being in private at all. And this is what they found. They went in and they looked, and they found video of Frank Williams and William Ward walking into the mall. And what had happened was Brandon had spotted Rodney Pritchett, and he kept following through the mall. And he called back to the gang leaders, who all got in a car and drove out to the mall. And then they walked through the mall trying to meet up with each other so they could catch Rodney Pritchett. And you'll see them here. There's Jermell Brandon with the shopping bags. He's going to meet with the 2 guys right there. And since you can't go commit a crime when you're carrying your shopping bags, you turn them over to your girlfriend, and then you go looking for Rodney Pritchett to show the gang leaders where he went. All through the mall, you can trace each one of these individuals as they look for the victim who they know is still in the mall. There they are walking down the side. There's the 3 of them. You're going to see a person with a gray sweatshirt on. He's going to get on the down escalator. That's Tyrone Brown. He has been summoned down to the lower levels where they've spotted the victim, where he's going to go out and shoot Rodney Pritchett. And this is the most important part. This is Rodney Pritchett. He's the one in the black jacket carrying the bags, walking out the door. Within 3 minutes, he's going to be dead. You're then going to see Jermell Brandon, the spotter, William Ward, the gang leader, and Tyrone Brown is going to follow him out and kill him. It's really important to pay attention to William Ward and watch his hand as Tyrone Brown walks out the door. Here they come now. And in case you missed it, that's the gang leader. See his left hand pointing? That was the sign to go get Rodney Pritchett. Brown is put at the mall by use of his cell phone. This is what my people go to court with now. You can show all the calls Tyrone Brown made and where he was pinging, which means initially he was down in Baltimore City when he gets a phone call, and eventually he's bouncing off the tower that's closest to the Towsontown Mall. As a result of what you just saw, plus a little bit more, William Ward got life without parole, Frank Williams got life without parole, Brandon got 20 years in federal prison, and Tyrone Brown got life without parole. All because we caught Frank Williams in the stairwell with his cell phone, and we grabbed the number and found out what his records are. This is how we solve crime nowadays in Baltimore County. Jason Gross lived over here on the east side of the county. He was looking on Craigslist for a female companion, and he found a girl named Rochelle Battle. This is what my prosecutors go to court with. Every time you make a cell phone call, we can track you and know where you are. So Jason Gross lives on the east side of town, and he makes a call from the cell tower nearest his house, calling Rochelle Battle. She lives on the west side of Baltimore, and she answers, and they talk to each other. Now, it's very interesting because when they brought Jason Gross in to talk to him, he said he didn't know who Rochelle Battle was and never talked to her in his life. So see, these records are being used not only to prove where people are, but to prove that they know each other and that many times people are lying about things. And what happened over the next hour is they made an arrangement to meet, and look what's happened. Rochelle Battle has taken the subway down from the Reisterstown area all the way down into Baltimore City. And they constantly talk to each other. And Jason Gross, who now initially when he talked to police said he's never talked to Rochelle Battle in his life, has talked to her at least 6 or 7 times on the telephone. Rochelle Battle continues to move across Baltimore. And remember, you think you're private? Nothing's private. The interesting thing about Jason Gross is he drove a very unusual truck. And the original picture is a little bit clearer, but he drove a Bobby's Potty truck. And so what the police did when Rochelle Battle went missing is not only did they pull Jason Gross in to talk to him where he denied that he knew her, but they walked up and down Eastern Avenue and pulled every video surveillance they could find. And what they found was a Bobby's Potty truck going down Eastern Avenue about the time Jason Gross's cell phone leaves his house. 2 interesting points. He said he never left his house that night. So now cell records and surveillance video have proved that he's a liar. And so then you see that he gets a call from, he has moved and left his house, and he's getting a call from Rochelle Battle. And now you can see what's happened is both their cell phones are in the very same vicinity. So this man who says he doesn't know her, doesn't know anything about her, never left the house, suddenly their cell phones are pinging off the same tower. And what happens next is they continue to try and reach each other. You think you have privacy? This is a video shot screen from a bus, a Mass Transit Administration bus. And that's Rochelle Battle getting off the bus at the exact same time period that her cell phone is pinging in the area of Eastern Avenue and Stemmers Run Road. So you can see how all this stuff comes together to prove things. Remember, Jason Gross said he never left the house? Well, he left the house that night, which he had lied about. He also said he went to a gas station, but not one with a convenience store. Well, that's Jason Gross walking into a convenience store. And guess what he bought that night? We were able to match the time where he walked in the convenience store with the store receipts, and it just so happened he bought a box of condoms that night. 2 minutes later, he's walking out. There's the truck going out Eastern Avenue back towards his house. There's a text message that Rochelle Battle receives. She's pinging off the tower closest to Jason Gross's house. She gets another phone call and text message. And then the next thing you know, nobody's ever found Rochelle Battle again. She disappeared off the face of the earth. We never found her body. This is a composite of the number of phone interactions that Rochelle had prior to her going missing in March of 09. And you can see she has thousands and thousands of phone calls, and then suddenly her phone disappears off the face of the earth. Those are the kinds of things that we use to convict Jason Gross of second-degree murder, and he's serving 30 years in jail for it right now. So what you're seeing here is that by grabbing a cell phone, using surveillance video, and using this kind of technology that we have, that's how you solve crime now. Nothing that you all are doing is private. The reason that it's not private is because you're voluntarily turning it over to your cell phone carriers free of will. Cell carriers initially learned how to charge people by the number of minutes that they were on their phone. That's why they always keep track of who you're calling and how long you talk. Cell carriers have to have towers around. That's the only way that they work. And the towers, therefore, provide location. They also keep a history log of who you've been calling in case you have a billing dispute. And the key element is, if you voluntarily turn that over to a commercial enterprise, then I, the government, can get it if I have the right kind of court order. So none of this stuff is private. The Towson Mall murder and the Jason Gross murder were solved and convicted using really what I would consider no real witnesses. Nobody identified anybody. Nobody said, oh, I saw him pull the trigger. It was all done with much of the evidence that you've seen here today. Internet is constantly being used to solve crime. We have things in our state, we call them sexual predators or travelers. They're individuals who go on the internet and meet young girls typically, interact with them. It's usually men who are interacting with them, and they lie about their age. And they build up a rapport and a relationship with these individuals. Well, I'm here to tell you that we have a detective who sits on the internet 24 hours a day, 7 days a week, pretending to be a 13-year-old girl. And by doing that, over the last several years, he's caught 11, 16, last year, 2 years ago, 24 individuals who drove to a location in Baltimore County thinking that they are meeting a 13-year-old girl, and they actually were met by detectives of the Baltimore County Police Department. So, you know, you can go on Craigslist and look for these guys, and they are looking and they're trolling, looking for victims. Because what you put on the internet is not private. It is not protected. Everything that you put out there, and that's why the police are able to grab these people off of this. How do we catch them? We look at Craigslist, we monitor that and see who's advertising, and then we communicate with the individuals and kind of lure them into committing a crime. They text back and forth with the detective, and he thinks he's talking to a 13-year-old girl. We have never lost a case. Of all those cases I put up there, we've never lost a case due to entrapment. They always wait for the offender to make the first move. We launch these things through social media. The investigation is conducted through text messaging. They arrange for a face-to-face meeting. When the person shows up, they grab their phone so they can verify that the person they've been talking to over the internet, or excuse me, over the texting, is the person that they've just apprehended. And they use the phone as the proof against them. We go get the phone records, prove the contacts that have been made, and show their own text to the court and the jury to use against them. It's not just sexual predators, it's also child pornographers. I'm sure a lot of you have used peer-to-peer computer sharing equipment. It's a great way to share music. It's a great way to download movies. Well, child pornographers use this stuff to exchange information. And these are the number of cases that we've had in Baltimore County in the last 8 years. It has exploded, the amount of information and the number of child pornographers that we catch. And the way that we catch them is we know that they're using these peer-to-peer sharing networks. It allows groups of computers to share a lot of information and exchange information. Well, child pornographers, that is how they share their videos and their pictures. So a lot of this software is stuff that you guys have probably used for music or movies, LimeWare, Nutella, eDonkey 2000. Well, the child pornographers use that too. And so how do we catch them? Police log on to the computers and they type in something like young girls and they see who's exchanging this kind of information. You think that's private? It's not. If you're using a peer-to-peer network, you're opening your computer up for people to look at, and you're taking the risk that anyone can look at it, including the police. Once you open yourself up, it opens you up to anyone out there, including the police department. They'll do a screen capture. They'll go to Comcast or IP address to find out what your name is and where you live, okay? Notice, this is the first time I've mentioned a court order in all these investigations. The first time. Now, we do need a court order to get your cell phone history, just like we need one to get your IP history, but much of this investigation that is being done without the intervention of the courts, because everything you're putting out there is not private. Then they go get a search warrant for your house. This is where the Fourth Amendment definitely comes in. I have to have probable cause to get into your house. But look how much information I've gotten already without having to get that search warrant. Once I get that search warrant, I go into your house, I grab every computer, we do a quick scan using Tableau. It's a scan that can download and lock your computer in place so we can't manipulate it, and we find the child pornography, and all those individuals that I showed you up there are gone to jail. They're going to jail for the crimes that they committed. So that's how we're using all of these internet and social media to try and solve crimes. There was a woman who lived on the west side of Baltimore County. She was very wealthy. She noticed her daughter noticed some things were missing, including a very expensive diamond ring. Daughter went on to Facebook. They had a housekeeper. They looked at the daughters of the housekeeper's Facebook page. There's the stolen diamond ring. Like I said, not everybody's so smart, all right? So here's a crime solved because a savvy individual looked at Facebook, checked out the housekeeper's daughter. With the Facebook picture alone, we got a search warrant to go into the house, and they found $100,000 worth of stolen property that had been stolen slowly over the last 5 to 10 years. You know, so that's how you solve a crime, solving Facebook. You think what's on Facebook is private? If Facebook were a country, it would be the third largest country in the world. 1 billion users. So the next time you type in to Facebook and say, heading to Florida for the next week, hope my house is okay, you might as well just leave the door open and tell people, come on in, take whatever you want. You have to check your privacy settings. Think about it. If you have no privacy settings on your Facebook page, you are telling 1 billion people what you are doing, including the police. And that's how we solved that one crime. The daughter brought us the Facebook picture. Next thing you know, search warrant in the house, somebody's going to jail. That's how we solved the crime. YouTube. Nothing on YouTube is private. That's why we all look at it. Everybody can look at it. That's the whole vehicle, which means the police can look at it too. We had a very serious assault over in Woodlawn, but the victim didn't report it and the witnesses didn't report it. But the police solved the crime because we monitor YouTube. And we don't need a court order for that. Everything you put on YouTube, you're putting out there for the world to see, including law enforcement agencies. And if there's a little edge to my voice, ignore that. I like that you all put everything out there. This is how we are solving crime. You know, between YouTube, Facebook, all these places, this is how we solve crime. So we did solve this crime, this assault. We actually had to go find the victim after we watched the YouTube video. So, how do I get this stuff? Because none of it is private. Well, Microsoft this year just released a finding of how many times law enforcement have asked them for information. I think Microsoft was the first company to do this. My understanding is Google is going to start releasing this information. But in 1 year, they got 70,000 requests from law enforcement, limited pretty much to the United States, Great Britain, and France. 70,000 requests in which we're asking for information about users. Who is this person? Because the stuff that was put out there was public, but now I need to find who's behind it. And the way I find who's behind it is by getting a court order. You post on YouTube, you give up your privacy. I can now use that in court any way that I want. A couple years ago, there was a horrible beating of a transgendered woman at a McDonald's over in Rosedale. We proved the entire case using a YouTube video. That's how we learned about it, and that's what was used in court to win the case. You post on Facebook, you give up your privacy. And that includes shielding things from police. Police always monitor Facebook. They always are looking at social media. We're always on the internet. We're always on Craigslist because these are the kinds of criminals that we're looking for. You are always telling your cell carrier who you called. That's how I find out who your co-defendants might be, how long you talked, where you were standing, and who your friends are. This information You are voluntarily giving up to a commercial entity, which means I can though go get it as a business record and use it for law enforcement purposes. If you reveal to a commercial party, then I, the government, get to use it if I have the right kind of court order. The Fourth Amendment, remember, applies to the government action, not the private parties, and not to commercial endeavors. Google and Facebook and whatever some kid who's in a garage right now who nobody even knows is inventing right at this moment, they all know more about you than your mother does. I guarantee you. When you go on Facebook, look on the right-hand side and see the ads that are directed to you. And see if they aren't directed to you, and it turns out they're all things that you've either looked up on the internet or things that you've shown some interest in. They know, it's data mining. They know exactly the kind of places you've looked and what you like and what you don't like, and they target their ads to you. You are voluntarily giving up all this information to a commercial endeavor, and they are using it to their advantage. How do I get this stuff legally? Well, I need a grand jury subpoena to find your historic toll records and call records. That means who you talked to, how long you talked. I need a grand jury subpoena to get an IP address. I need a grand jury subpoena to get a Facebook user information. So if you've put something out there and I want to find the person who's behind it, it really isn't very hard to get that information. I do not need to rise to the level of the Fourth Amendment and get a search warrant. Cell tower information, where you were standing, I do need a judge's court order. And therefore, I only have to show probable cause that the phone was involved in a crime or near the scene of a crime, or there's something about the phone that links a person to a crime. And I can go get a court order to get that. Again, the courts have not said that this has risen to the level of the Fourth Amendment where I need a search warrant. Surveillance video, usually the businesses give us to those voluntarily. Usually if you go to the Exxon station and say, hey, we want to check out your video surveillance, they'll turn that over freely. Sometimes we have to give a grand jury subpoena or a court order, but most times they'll give us a copy of it freely. Remember, you walk into that store, you're giving up your privacy because people can know that you were there. And the rationale under the Fourth Amendment is that if a police officer were standing there watching you come in, then why can't we use technology like surveillance video to watch you come in and then allow the police to look at it later? And that's what the logic is behind all of that. Real-time cell information. So if John were thrown in the trunk of a car out here and somebody saw it, and I wanted to know, where that car went because I think he's the victim of a kidnapping, if I want real-time cell phone information, we do need an oath and a statement explaining it to a judge and convincing a judge. However, if we really think he's kidnapped and it's a dangerous situation, the cell phone carriers will usually turn that over to you automatically and let you get the court order later if they felt like John was in danger, like a kidnapping. But if I wanted to know where somebody was standing right now, where's Scott Shellenberger right now going to AT&T, you would need a court order with an oath telling a judge why you needed that information. So you can see as the level of privacy goes up, you walk into a store, surveillance video, they turn that over voluntarily. Who did you talk to? Not what you said, who you talked to. You need a higher level. And then where are you standing? You need a higher level. So there are provisions built in here for more and more protections for privacy, but still not a lot. To get a computer from a house, you need a search warrant. And that goes back to the original founding of the Fourth Amendment. Remember the whole concept of keeping the British soldiers in houses and letting them stay there, or having British soldiers bust down the door to look for information that you may be against the king. That's what the Fourth Amendment was for, guarding that door, that home that you have. And for me to get into your house, I need a search warrant, always. Unless there's really exceptional circumstances. There are a number of exceptions. But for the most part, to get into your house, I need a search warrant. And that's what the Fourth Amendment was designed for, not only these things that you reveal to the public voluntarily. But there's a new area of constitutional law, and that's exigency. That is there an emergency? And one of the things I think you're going to see over the next couple of years is a scenario like this. A horrible crime has happened, the police have pulled over a car, they've grabbed somebody, and they want to look at their cell phone right away because they think it's an emergency. Either we're going to catch another gunman, or we're going to find out about more victims of crime. And I think this is the place where you're going to see the most debate about the use of cell phones and its clash with the Constitution. Text messages are only saved by the carriers for about 48 hours. And because people your age are using so many text messages, that time period is going to continue to get smaller and smaller because they can't have enough servers to hold all these text messages. So this might be the place where if a robbery happened, the police chase some people, they catch one of them, they want to find out who the co-defendants were and who they were texting with over the last couple hours. This will be the place that'll test that. And that'll be, did the police have a right to grab your phone from your hand when you're under arrest and look at its content without a search warrant? I don't know how that's going to come down because this exigency, the fact that texts only stay around for 48 hours and probably less very soon, may have created enough of an emergency to allow the police officer to look at your phone. That is the area that we're going to see a lot of movement in. A wiretap, listening to what you're saying on the phone, is the highest level of protection by the Fourth Amendment. I told you earlier I have 59 assistant state's attorneys who prosecute crimes under my name. This is the only thing in the whole state of Maryland that I have to do myself. I have to, if I want to listen to your calls or have the police listen to your calls, I have to go in front of a judge, take an oath, and swear why I need to listen to your calls. I cannot give that to one of my assistants. That's a requirement here in the state of Maryland that the actual state's attorney has to sign and swear to the need for a wiretap. So you can see the levels of protection that are built in, and as you get more privacy, there can be nothing that we would consider more private than what's in our home, and therefore you need a search warrant, or what we're saying on the telephone, and therefore you need the state's attorney to say to a judge exactly why you get it. So there are privacy elements built in. But remember, when you're talking on the phone, typically you're trying to keep the conversation between yourself and the person you're talking to, although I know many of us have listened to conversations now in restaurants, movies, and stores where it's obvious that people don't care who listens to what they have to say. But traditionally what we say on the phone we consider to be very private. Traditionally what we have inside our house is very private. But remember, that computer is your link to the outside world. And just because that computer's in your bedroom, in your house, locked away, if you're releasing information to the outside world, then you have given up much of the privacy that the Fourth Amendment has protected. The Constitution is ever evolving. I said at one of my prior times, back in 1791, when the Fourth Amendment said you shall be secure in your persons, places, and houses and effects from unreasonable search and seizure, it was really easy to know what that means. Nowadays, knowing what that means is very difficult because of the amount of information that is out there about us all over the internet. Do yourself a favor, go Google yourself one time and see how many things come up. You might be very surprised at how much information is out there about you. And remember, none of this stuff that you put out there is private in any way. Not only can everybody see it, including employers, so keep that in mind before you post something stupid. I check and look at people before I hire them. I check on the internet to see what they've been posting. But more importantly, you now see how law enforcement has used all this in order to solve crimes. The day of coming into court with a single eyewitness who says he did it, it's all over. You now come into court with a single eyewitness to say he did it, and then you bring the surveillance video in, and then you bring his cell phone records in to show he's pinging off that tower, and then you bring in who he talked to in the last 2 hours to prove who drove the getaway car. And that's how technology is being used to solve crime nowadays, and that's how really the Fourth Amendment doesn't protect as much as you think it does. Thank you.
Does anyone have any questions at all, or anything anyone would like to ask?
I have a question. Since we're speaking on social media, I have a question about if the state's attorney uses social media along with mainstream media to catch criminals, why wasn't the serial route information and pictures put out back in November 2007 to catch him when the state has that information? But an innocent Baltimore City officer named Aaron Seizures info was. Is it only the job of the state to do is convict or protect the innocent people of a state such as Mr. Seizures, who was falsely convicted, and the real suspect goes free?
Okay, I'll summarize. I can't answer you about the specific case, but I can tell you generally. So the question deals with, is it the state's job just to convict, or do we also have a duty to make sure that innocent people go free, and how can this technology be used to help that? Number one, the state's job is to see that justice is done. And we have a duty to not only make sure we only convict people who are guilty, we have an affirmative duty to turn over what's called exculpatory information. That is information that tends to prove someone is innocent. So I can give you a good example about a case I have right now. In 1999, an individual named William Jameson committed a horrendous rape, and I prosecuted him as a young prosecutor. He was convicted. He got life plus 40 years. DNA was collected in that case, but there was very little DNA there. And the technology wasn't good enough in 1999 to even test that DNA. Fast forward to 2 years ago, he got a lawyer with the Innocence Project, and they said to me, we want the DNA and we want to test it. I had to turn that over. I didn't try to block that. It was turned over. It's been tested. The test is kind of inconclusive, but I have that affirmative duty to hold that evidence and, in fact, turn it over. And so every prosecutor in this state, and really every prosecutor in this country, has an affirmative duty to turn that information over. I don't know enough about that case from Baltimore City to specifically answer that question. I can tell you that sometimes when we're trying to solve crime, you don't always want to put this information out in the media early on. So for instance, in the Jason Gross murder case, it was very crucial that we caught him in so many lies. I didn't know her, I never talked to her, I didn't leave the house, I went to a gas station store but not a convenience store. If we had put all this information out early on, he would tailor his statements to us to match the evidence that we had. And really, one of the crucial things in this case was how many times he lied and how many times we caught him in lies. So that might be a reason why early on in an investigation, you would want to hold information back. But we have an affirmative duty under the Constitution, Due Process Clause, to always turn over information if it even tends to make the defendant have some evidence of innocence. And my people hold that duty very high. Anybody else? Yes, sir.
A few years ago, there was a guy on a motorcycle riding on I-95 who had a helmet cam on.
Right.
And he got off 95 on that ramp. I guess there was a state trooper in front of him. State trooper pulls out, jumps out of his car, pulls his gun out. He's plain clothes. Anyway, he was helmet cam on.
Right.
And it was also recording audio. To me, they're still in a public place. He had the right to record the stop.
I know where you are. We can do this. Okay. So the issue is, several years ago, helmet cam, got stopped by the police. He was recording the arrest and the charges. And that goes back to what we were talking about before, that wiretap statute. Maryland's wiretap statute is very broad. It basically says that you cannot record any intercepted communications. And while most people believe that's just the talking on the phone, it actually means talking all the time. So in other words, under traditional constitutional principles, if John and I are talking, he couldn't have a tape recorder in his pocket and record our conversations. That is considered to be wiretapping. And in Maryland, we are what's called a two-party consent state. And that is, if you want to tape someone who's talking, both parties have to consent. Now, the reason the surveillance videos aren't a problem is because they're just videos, they're not recording sound. And that was the issue up in Harford County with that I-95 motorcyclist. His helmet cam recorded sound. And so they charged him with a wiretap violation, recording sound without two parties consenting. A couple things happened on that issue. Number one, my recollection is a judge threw it out because of what you said, and that is they were in a public place and a police officer is a public person, and therefore he doesn't have to consent. Number two, the Attorney General of the state, Doug Gansler, later on issued an opinion reaffirming that, and that says that police officers, when they're acting in their official duties, are allowed to be recorded while they perform those duties. So now here's the issue. I had a case about a year and a half ago where an individual came in and was recording the officer while he was eating lunch. So then the question is this his official duty or not? He had just given the individual a ticket outside, and now the guy came inside to confront him and was recording the entire thing on an iPhone. So that's an area that's kind of sketchy. You may know that the Mass Transit Administration has done a recent effort to put not only video on their buses, like I showed you, but audio on their buses. And there's a lot of folks who are upset about that because they say, look, this is a violation of the wiretap statute, and just having a little postage-size warning on the front of the bus when you're getting on might not be giving enough notice. But for the most part, Maryland is a two-party consent state. If you want to record anything that an individual has given, in fact, your television folks had me sign a release today agreeing that this would be videotaped and audio taped. And that traditionally has to be done. But there are some changes now that's happening with regard to law enforcement, and that's a perfect example you gave us. Anybody else? Yes, ma'am.
I'm not saying I believe one way or the other, but I'm just wondering, if you're not allowed to, without consent, audio record someone, how come you can use YouTube in court when YouTube has audio?
Well, number one, every state is different. Some states are one-party consent, so which would then mean the person who's holding the camera has consented, and therefore that's okay. Maryland happens to be a two-party consent state. The second thing is, once it's put on public display, then you've given up that privacy right. But I actually think that's a really good point, is for, so you may want to think about going to law school, is for you to come in and argue, Judge, Maryland's a two-party consent state, you have no information that both parties consented, and just because that happened in Montana and they're trying to use it here, you shouldn't be allowed to use it. I mean, I had a child abuse case 20 years ago where the victim put a tape recorder under the bed in her room. The perpetrator came in and you could hear was committing child abuse. I couldn't use that in court because he had not consented. And so this concept of YouTube and me being able to use it in Maryland courts, we haven't found a lawyer who's smart enough to say anything about it yet. Go ahead.
So say someone had an audio recording and it was also visual, and then they uploaded it to YouTube. Could they then use that as evidence because it was on social media?
My argument would be that they've given up the right because it's on social media. I think the interesting argument would be if I'm recording it, the person getting recorded is the defendant, and his words are going to be used in court. Like, I just killed so-and-so. That would be a fascinating issue because he could say, I didn't consent. And just because it was on his phone, I didn't consent to him recording it, or I didn't consent to him uploading it. I think that's been a really interesting issue, and I'm sure it'll happen one time soon.
Last question.
Yes, sir.
Are you an advocate for Baltimore County officers wearing cameras, like Baltimore City? They're starting a new pilot program, officers with cameras.
Yeah, that's interesting. There's a new move afoot in law enforcement, I think in New York, Laurel, and I think they're starting a pilot program in the city. is to have all officers have a small video camera that records constantly, either on their shoulder or on the brim of their cap. It's something that I'm willing to take a look at. You know, I just worry about whether or not it would interfere with officer safety. I worry about the expense. We have over 2,000 sworn officers in Baltimore County. Everybody would need their own video equipment. Then you look at storage space. You know, where do you store all these videos? How long do you keep them? You know, our police department has thousands of interactions with citizens every day that never result in a crime being charged. You know, would we have to save all of those, and for how long? So I think there are a lot of issues around that issue that I would really have to have answers for. But I would certainly, you know, take a look at it and keep an open mind about it. I'd be interested to see how these pilot programs, I think I said New York City, I think, is starting one too. Okay? Anybody? Yes, sir.
In Baltimore County, do the police department in Baltimore County have dash cams? I assume so.
No. No. The Maryland State Police has dash cams. That's mainly because of the number of DUI arrests they make, and they're utilized that way. But the Baltimore County typical police cruiser doesn't have a dash cam. You know, this technology conversation is getting so interesting. I had a talk with the police chief just a couple weeks ago. He said that there's so much material and equipment in his police cruisers right now that he can't do ride-alongs anymore. If you look at a police cruiser, you know, on the passenger seat in the front, there's now a laptop that has e-tickets that can hook into all kinds of databases. They have so much equipment in the front of their cars right now that it's really hard for them to do ride-alongs. I guess it wouldn't be hard to add dash cams, but again, another big expense and another storage issue about as far as how much you have to store. Any other questions or comments? We've been a great group. Thank you all so much.